Thanks, Laurie, for the introduction. I'm not convinced I'll do it justice, but thank you. Secondly, Kim, thank you for your introduction to do with safe harbours. I think it is very relevant, obviously, to what we're talking about, and you know, a lot of it resonated with me. And even though eBay is probably in your category of behemoth, I think that I think that you'll see we have our own challenges, and I'm happy to discuss them. So I'm going to tackle the question of takedown notices, and in particular the question of adequate notice in Australia. And I hope to be able to demonstrate some of the difficulties with the current approach to this in practice. Before I start talking about that, however, I want to discuss a case decided in the US. It is a case of Hendrickson versus eBay, so one of our own cases. It was concerned with Section 512 of the DMCA, which is obviously the takedown safe harbour provisions. Hendrickson was the owner of the copyright for the documentary movie Manson. Hendrickson sued eBay for secondary copyright infringement after he unsuccessfully tried to have listings removed of the movie from the eBay site. eBay argued that as a service provider, it was protected by the DMCA. There were three prongs for eBay to have to overcome. Firstly, actual knowledge. In this case, that wasn't relevant because eBay had no actual knowledge prior to being notified. Second was vicarious liability. It was held that eBay was not vicariously liable because even though it may have had the ability to control or remove the listings, the test is right and ability, not just ability, and it was held that eBay did not have the right. This is actually quite a fascinating topic, and not one that I'm going to delve into today because it's a large topic, but I will raise it again briefly in the context of takedowns in Australia. The third prong was adequate notice. Hendrickson failed to provide adequate notice. He did not identify any of the particular listings which infringed on the site, so rather he just did a general notice to eBay saying that they were infringing. Had he actually written down the listings that were being infringed, my guess is he would have won. The seller then, once he had asked for those listings to be removed, would have had the opportunity to issue a counter notice. This is how the DMCA works. And then eBay would have had to reinstate the listings upon receiving a counter notice. Then, if the rights owner still maintained he had rights over it, it actually would be between the parties to have to issue a court order to eBay to remove it again. So now let's put this into the Australian context. In Australia, if a rights owner notifies eBay of a copyright infringement, eBay does not have the protections of the DMCA. In fact, well, not in Australia, obviously. In fact, it becomes quite a challenging scenario. And the reason for this is because it becomes apparent often during these debates that the rights owner may not in fact have the rights they think they have or assert they have in certain circumstances, or at least eBay as a service provider cannot know whether they have those rights. Most of you are probably aware of eBay's Vero program, which is a process largely designed to fall within the DMCA process. It allows a process of takedown notification through what we call a NOCI, which is a Notice of Claimed Infringement form. In the US, for a copyright claim, this gives the seller an automatic right of counter notice. In Australia, we don't have this automatic ability to have a counter notice. It is much more complicated. If a rights owner tells us to take down a listing and a seller tells us no, they had the right and they wish to have it reinstated, we don't have any protections. You have a situation where both parties are claiming to sue eBay, one for taking down, the other for not taking down. Arguably, only a court in this circumstance is equipped to verify the validity of the rights owner's claim. The question is whether being on notice is adequate notice. What if the claim is false? If we need to go as far as to verify the merits of the claim, then surely the concept of being on adequate notice is flawed. The reality is, in these circumstances, only a court order would be sufficient to put us on notice of the veracity of a claim. Australian law doesn't cater for this scenario at all and places a high onus on service providers to arbitrate or consider the merits of a copyright claim. If there was some process where service providers could rely on a rights owner's claim at face value without repercussion or exposure to the service provider, then it would make this a much cleaner and clearer process. The current scenario seems to shift the obligation of deciding a legitimate rights ownership challenge from the parties involved in the dispute to the service providers, who are simply providing the platform for sharing or accessing the material. This is where I want to briefly re-raise the concept of right and ability, because where a service provider can't determine the dispute, arguably it doesn't have the right to remove the content, even if it has the ability. And maybe this is what the court meant in Hendrickson when it said that eBay didn't have the right, even though it had the ability. It is an interesting concept that, as I said, we're not going to explore here. In the meantime, eBay continues to grapple on a daily basis with the competing interests of rights owners and users, and the obligation to protect those rights, which we feel to be more heavily weighted on eBay as a service provider rather than on the parties themselves. I realise this is just a glimpse of some of the issues, but I hope it's sufficient to provide an indication of some of the practical challenges we face in the current environment.